I'm thinking it is.
When Sweet Pea taps in, you know the courtroom lights go bright. Trials running long, but the family's here every night.
Take it to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. Cause Sweet Pea's on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when Sweet Pea's in the building, we be learning with pride. My eyes on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Rachel with the facts, pretty brown girl with the sass. Moreldia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate. Take it to trial, where the truth gets loud and the laughs run wild. Sweet Pea's got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you're out of line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet Pea's got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made of gold. Hey! Take it to trial, from day to night and every wild mile. Sweet Pea's million strong with her trademark style. And the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial. Yeah, we live tonight. Take it to trial. Yeah, we live tonight. Take it to trial.
Whoa, yeah! Woo! Yeah! Courtroom packed and the cameras on. Folks all whispering won't be long. No more smirks and no more lies. Judge looked down with narrowed eyes. Bailiff waiting by the side door. Steel-toed footsteps on the courtroom floor. Whole chat buzzing like the verdict dropped, but the jury room still got them locked. Hear the cell doors lock. No parole board, baby, round the clock. One-way trip and the bus won't stop. Everybody clap to the L-Wop-Bop, L-Wop-Bop. No appeal gonna save you. Orange jumpsuit, tailor-made flavor. Sink that feeling when the gavel drop. That's the rhythm of the L-Wop-Bop. rhythm of the L-Wop-Bop. Mama crying in the second row, defense still talking, but it's moving slow. State dock receipts and the pressure's steep. Now the whole room barely even breathes. Used to talk big for the TV lights, now it's long breaks and uneasy nights. Woo! Funny how the swagger disappeared before a single word got clear. L-Wop-Bop-Bop, hear the cell doors lock. No parole board, baby, round the clock. One-way trip and the bus won't stop. Everybody clap to the L-Wop-Bop. L-Wop-Bop-Bop. No appeal gonna save ya. Orange jumpsuit, tailor-made flavor. Sink that feeling when the gavel drop. That's the rhythm of the L-Wop-Bop. Hey, 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 hey. The L-Wop-Bop. Hey, 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 hey. That's the rhythm of the L-Wop-Bop. Hey. Case pause, courtroom tense. Hey. Everybody waiting on the call.
Order in the court! Order in the court! Order in the court! Sweet pea gang! Take it to trial! Lights on, court live, evidence all night. No spin, no lies, no fluff, just facts. Take it to trial. Take it to trial. Take it to trial. You be the judge. Take it to trial. Take it to trial. Take it to trial. You be the judge. Witness on the stand, truth's in demand. State says guilty, defense got a plan. Jury in the box, tick of the clock. Everybody watching, waiting for the shock. Who do you believe? What do you see? Sweet pea gang. 1, 2, 3, take it. Take it to trial. Take it to trial. You be the judge. No filter, no fluff, just facts. That's us. Verdict watch, verdict watch, verdict watch. Everybody stop. Hold your vote, hear the proof. Courtroom pressure, seeking truth. Take it to trial. Take it to trial. Take it to trial. You be the judge. Sweet pea gang. Sweet pea gang. Sweet pea gang. Court is in session. Case closed. Or is it? Take it to trial. Go to jail, go to jail. 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 Go to jail, go to jail, go to jail, go to jail. Don't collect that 200s, take your ass straight to jail. Gavel hit, case closed, now the truth done set sail. Take it to trial in the building, baby, straight to jail. Pulled up in court, yeah, the facts on deck. No filter, no fluff, we just call what's next. If the lies don't match and the stories derail, pack it on up, baby, straight to jail. Judge on the bench, whole chat going wild. Sweet pea on the mic, like, hold up, that's foul. You be the judge, but the evidence loud. When the verdict come back, we don't do no soft crowd. Go to jail, go to jail, go to jail. Don't collect that 200s, take your ass straight to jail. No pass go, no spin, no magical fairy tale. Take it to trial, said what? Take your ass straight to jail.
everybody rise. Everybody rise.
Yeah, yeah. Junkie on the freeway, white claw in a breeze. 2 hours there, 2 back, still typing with ease. LA lanes locked, but she don't slow down. Show up every time, yeah, she runs this town. Sitting in the traffic, but she locked in check. If Sweet Pea goes live, yeah, she's right on that. From the 405 to wherever we at. Junkie pulling up like y'all good, I'm back. Different time zones, same front row seat. No matter where we are, we all meet in the feed. We the California's rolling deep online. 4 corners, 1 crew, yeah, the vibes align. From the coast to the chat, yeah, we show up right. If you're lost downstream, we gon' guide you like Californians. Yeah, we stay in the mix. 4 names, 1 flame, you can't remix this.
SD rolling with the sunset glow. West Coast haze where the good vibes flow. Little bit lifted, yeah, she stays serene. Ocean breeze mixed with the evergreen. Late to the stream, but she still gon' slide. Panel opens up, she already inside. Hold up, I'm here, yeah, she dropping bars. Calm, cool energy, no matter how far.
She got that FOMO, scrolling every stream. Little lost downstream, but she part of the team. New to the crew, but she locked in fast. Super chats flying, yeah, she built to last. Wait, where we at? But we got her back. Pointed to the right stream, never off track. Now she vibing with us, no need to roam. Anywhere we at, yeah, Susie home.
Shamrock, yeah, Shamrock checking in from across the map. Different time zone, but she bridging the gap. Y'all good every time, yeah, she mean that. Heart so big, you can't teach that. Algorithm running, she keep it alive. Dropping love in the chat, keep the whole thing thrive. Quiet power, steady hand in the dark. Every stream glowing, got a Shamrock spark.
Yeah. Junkie, 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 junkie.
Susie, Shamrock, Shamrock.
Junkie, 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 junkie.
Susie, Shamrock, Shamrock.
We the California, say the name twice. Show up every stream, yeah, we never think twice. From the traffic jams to the ocean tide, from the lost links to the worldwide ride. Californians, yeah, we stay in the mix. 4 names, 1 flame, can't remix this.
When the live stream flickers on and Sweet Pea takes a stand, Lynn is already there, coffee in hand. She settles in for the long trials, the twists and the turns, with a loyal heart and steady eyes that never miss a word. She's a constant in the courtroom, a familiar shining face, always ready for the arguments, the tension and the pace. And when the evidence is messy or the stories sound untrue, she leans forward just a little. Lynn knows what to do, 'cause Lynn thinks everyone is guilty, every suspect, every tale. Melody Ferris guilty, she says without fail, but Dr. Rachel shakes her head. Sure, the son is to blame, still Lynn stands firm, her verdict stays the same. Oh, she brings the truth with a calm, steady light, and her presence is a comfort on every trial night. She listens with devotion through each objection and plea, through the cross-exams and pauses. She's where she needs to be, in the sea of courtroom chaos where tempers sometimes flare. Lynn remains unshaken, a voice of reason there. And though the chat may chatter and the theories may divide, Lynn's perspective never wavers. She speaks with honest pride. She keeps the room grounded when emotions run loose. A quiet force reminding us she's here to find the truth. Yes, Lynn thinks everyone is guilty, that's just her way. From the first opening statement to the end of the day, Dr. Rachel can argue the son's the one at fault, but Lynn won't budge. She's rendered her final thought. We appreciate her always for her loyalty and her proof, 'cause the chat shines a little brighter when Lynn brings the truth.
Oh, it was muted. Sorry, Barb. No, I was just saying, oh, Lee. Oh, Lee, definitely. I know you signed up for Discord. We definitely, you're in our prayers. Definitely reach out on Discord if you need any support emotionally. You know, they always there, different time zones, different places. Um, oh my, definitely praying for you and the family. Definitely, definitely, definitely. It's a hard time. I'm so sorry to hear that. Yeah, I was just sitting up here doing my gripe, so I don't know if that's something that you want to hear. I was just saying how trifling this course is to me. It's like they 30 minutes late. They always late. He is never on time. It is not about the case to me at this point in time. All I'm complaining about is the way he has operated this courtroom as far as the schedule. And if I was a juror, I would be upset with him. I would be heated with him every single day. And I do mean every single day. Like, what a waste of time. Like, no respect for anybody else's time. But with it being said, we are winding down. We will be out of this courtroom sooner rather than later. We just have closing arguments and then we go into verdict watch and then we can move on with our lives. Like, This case has divided all types of YouTube communities, all types of people, their thoughts. It made people actually think in regards to what mental health is, what is not, what mental health systems do for our communities, and what it does not. And I think that it has just brought out a whole lot of different things in people. So, and it has brought out a lot of ugliness in people too. I will say that. 'Cause I think a lot of stuff has been very, very ugly. In the YouTube communities. So, as I stated, they're still not there. They're not ready. They're not going. But let me check something else. I have something else that's very. Shayna Gardner is going to be in court. You know, Mario Fernandez, he was convicted and found guilty on 2 charges yesterday. And his girl, Shayna, she going to be in court today. So she appears in court after her husband is found guilty of redrumming Jared Bridegan. So if this court system does not start showing what they need to show, I am going to actually take us into that hearing, to be honest with you guys. I wonder what she gonna do. Could she plead guilty now seeing that Mario was found guilty? Holy moly. I don't know. Well, let me say our good mornings. Barb was first up in the place. Hey, Rhonda, how you been doing? Hey, Brian. Good morning, Jason. Hey, Cian. Hello, hello, hello. Yes, like what? Could she be coming in to talk about she want to plead guilty or change her plea or something? After seeing her husband? Hey, Cian. Hey, Funk. Hey, lady, good morning. I'm thinking to myself, could that be a possibility? Oh, my goodness. Because this hearing was not scheduled. Not that I'm aware of, it was not scheduled. Oh, aye. They got a full courthouse. They got a full courtroom today for closing arguments, baby. Let me show y'all. It look like they got closing arguments about to get ready to get started. I really want to see what Shayna got going on, but we'll go into the closing arguments. God, she looks so dark and so mean.
All persons having anything
And closing arguments begin.
to do before the Honorable William Sullivan, Justice of the Superior Court, now sitting in Plymouth within the full of the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now in session. Please be seated.
Good morning, Your Honor. May I proceed?
Yes, please.
Your Honor, before the court today, we have the continuation of the jury trial in the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shannon Buckingham.
All right, thank you, Madam Clerk. Well, good morning, everyone. All right. Well, you know how we're going to start this? I'm going to ask you those questions. And just in case you're wondering, does this podium up here mean that I'm going to talk to you for quite a while this morning? It does. All right. So first, let me ask you the questions. Has any member of the jury read, seen, heard, or overheard anything from any source about any aspect of this case that would affect your ability to be a fair and impartial juror? All right. Secondly, is there any other matter or concern bearing on your service as a juror in this case that anybody needs to bring to my attention at this time? All right. Again, as I've said for weeks now, thank you for following those instructions. And so where we are now in the process is, I just want to explain a little bit to you. We're going to do what we call the arguments in charge. All right. And that just means I'm going to give the charge as my instructions. All right. I'm going to instruct you on the law that you are to apply in this case to the facts that you're going to find. And then the argument part is we're going to hear the closing arguments from the attorneys. And the way we do it the way I do it is I kind of split it up. So I'm going to give you first half of my instructions. We'll talk a little bit about the specific charges in this case. And then after the closing arguments, I'll come back and give you some more general instructions about how you, the burdens of proof and how you are to go forward.
Wait a minute. What is this on the thing? Is these pills? What is this on her thing? What is this about? I'm sorry I had to stop this in the middle because somebody about to tell me what is this on this desk right here, y'all. Y'all see this? Where my cursor is? Y'all tell me, what is this? Are these pills? Are these like, what is that? I want to know what is that? And why is it there? I cannot start the feedback up until y'all explain to me what is that. I need to know what it is. Please. If you just lurking and please look at the feed because I need y'all to tell me what this is because I do not want to go through this entire trial thinking these are pills or something on here or I don't know. Like I need to know. It's her medicine. Why is it? Well, why is that? Maybe he gonna show the pills to the people during closing arguments. I don't know. Is she gonna grab them back? I don't know. Oh gosh. Okay. Whatever. Let's go.
Forward and do your deliberations and handle the deliberations.
Maybe it's Tic Tacs
All
or a
right?
snack.
So they take a while, all right? They can be, well, they can't, I was going to say rather dry, but they are dry. And so what the parties and myself have agreed to do is I'm going to print out, we printed out the instructions that I'm going to read to you. So you'll have those with you, all right, as we go through this morning. And so some people find that helpful to read along and comprehend. Some people don't. So if it's distraction, you don't have to read it. But some people find it helpful, so we thought we'd do that. You also should know that you'll have these instructions. You can bring these with you in the deliberations. So you'll have this whole outline of what the law is so that you are to apply. All right? So at this point, if we could hand out the copies of the instructions. Oh, you already have those? Oh, geez. I forget how efficient our court officers here are. So what I'm going to do is I'm going to start the instructions now. All right? So my instructions on the law are going to be delivered to you in two phases. As I said, first, I'm going to instruct you on the specific indictments that have been brought against Ms. Clancy. After I conclude my instructions regarding the charges, the Assistant District Attorney, Ms. Sprague, and Attorney Reddington will each deliver their closing argument. Remember, the arguments of counsel are not themselves evidence. They're provided to assist you in organizing and understanding the evidence that's been presented during the trial and the conclusions that each party would like you to draw from that evidence. At the conclusion of the attorney's closing arguments, I'll give you the second part of my jury instructions. And in that phase, I will give you go over a number of very important principles that will guide your overall evaluation of the evidence, your deliberations, and your eventual verdicts. The instructions are to be taken and considered in whole. All right, so the first and second part are equally important. So you to consider all of my instructions as a whole. You'll notice, as I said, I'm reading these instructions to you. Excuse me, I apologize for doing that, but I have to give these instructions clearly and accurately. So as I said, to assist you in your deliberations, I provided you with written copies of these instructions. However, those written instructions are not a substitute for the oral instructions I'm giving now, so please listen carefully. All of my instructions are equally important. You're not to overemphasize one portion of these instructions or ignore other portions. These charges have specific factual elements that the Commonwealth must establish beyond a reasonable doubt, and I'll review those elements with you in detail at this time. Now remember, that the law presumes the defendant to be innocent of the charges against her. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt. So now I want to go into the instructions that are specific to this case. First, I'm going to have a drink of water. Thank you. Now, in this case, Ms. Clancy is charged with 3 counts of murder. I want to talk first about the issue of criminal responsibility. All right. Now, to prove the defendant guilty of any crime, the Commonwealth must first prove beyond a reasonable doubt that the defendant was criminally responsible at the time the alleged crime was committed. The Commonwealth bears the burden of proving beyond a reasonable doubt that the defendant committed the crime with which she is charged, and also that the defendant is criminally responsible for her conduct. The defendant has no burden to prove a lack of criminal responsibility. Criminal responsibility is a legal term. A person is not criminally responsible for her conduct if she has a mental disease or defect, and as a result of that mental disease or defect, she lacks the substantial capacity either to appreciate the criminality or wrongfulness of her conduct or to conform her conduct to the requirements of the law. The phrase mental disease or defect is a legal term, not a medical term. It need not fit into a formal medical diagnosis. The phrase mental disease or defect does not include any abnormality characterized only by repeated criminal conduct. It is for you to determine, in light of all the evidence, whether the defendant had a mental disease or defect. If the Commonwealth has proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect at the time of the killing, the Commonwealth has satisfied its burden of proving that the defendant was criminally responsible. If the Commonwealth has not proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect at the time of the killing, then you must consider whether, as a result of a mental disease or defect, the defendant lacked the substantial capacity either to appreciate the criminality or wrongfulness of her conduct or to conform her conduct to the requirements of the law. To establish that the defendant had the substantial capacity to conform her conduct to the requirements of the law, the Commonwealth must prove beyond a reasonable doubt that any mental disease or defect that may have existed did not deprive the defendant of her ability to behave as the law requires, that is, to obey the law. The word appreciate means to understand rather than merely to know. Criminality means the legal significance of conduct. Wrongfulness means the moral significance. The Commonwealth must prove that the defendant knew and understood that her conduct was illegal or that it was wrong. It's not enough for the Commonwealth to show that the defendant merely knew or was intellectually aware that her conduct was illegal or wrong. Rather, the Commonwealth must prove beyond a reasonable doubt that a mental disease or defect did not deprive the defendant of a meaningful understanding of the legal or moral significance of her conduct. The defendant must have been able to realize in some meaningful way that her conduct was illegal or wrong. In considering whether the Commonwealth has met its burden of proof, you may consider all the evidence that's been presented at this trial. You may consider the facts underlying the crime and evidence of the defendant's actions before and after the crime. You may consider the opinions of any experts who testified and give those opinions whatever weight you think they deserve. Now, in a moment, I'll instruct you on the elements of the offense that the Commonwealth alleges that the defendant has committed. Remember that the Commonwealth must prove to you beyond a reasonable doubt that the defendant was criminally responsible at the time that the crime was committed. That is, that the defendant did not lack criminal responsibility at that time. Therefore, it is the Commonwealth's burden to prove at least one of the following beyond a reasonable doubt. One, that at the time of the alleged crime, the defendant did not suffer from a mental disease or defect. Or two, that if the defendant did suffer from a mental disease or defect, she nonetheless retained the substantial capacity to appreciate the wrongfulness or criminality of her conduct and to conform her conduct to the requirements of the law. Now, as I have previously instructed you, your decision should be based solely on the evidence and the law of this case. If a defendant is found not guilty by reason of lack of criminal responsibility, the district attorney or another appropriate authority may, and generally does, petition the court to commit the defendant to a mental health facility or to Bridgewater State Hospital. If the court concludes that the defendant is mentally ill and that her discharge would create a substantial likelihood of serious harm to herself or others, then the court will grant the petition and commit the defendant to a proper mental health facility or to Bridgewater State Hospital. Periodically, the court reviews the order of commitment. If the defendant is still suffering from mental disease or defect and is still dangerous, then the court will order the defendant to continue to be committed to the mental health facility or to Bridgewater State Hospital. There is no limit to the number of such renewed orders of commitment as long as the defendant continues to be mentally ill and dangerous. If these conditions do continue, the defendant may remain committed for the duration of her life. If at some point the defendant is no longer mentally ill and dangerous, the court will order her discharged from the mental health facility or from Bridgewater State Hospital after a hearing. The district attorney must be notified of any hearing concerning whether the person may be released, and the district attorney may be heard at any such hearing. However, the final decision on whether to recommit or release the defendant is always made by the court. Now, I'm going to go over at this point the specific elements of the charges against Ms. Clancy. So I want to talk first about murder in the first degree. The defendant is charged with 3 separate indictments charging murder, 1 count each relating to Cora Clancy, Dawson Clancy, and Callan Clancy. The instructions I'm going to give now apply to each separate indictment relating to each child. There are 2 different degrees of murder. There's murder in the first degree and there's murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. The Commonwealth alleges that the defendant committed murder in the first degree on the following theories. First, that it was murder with deliberate premeditation, and then second, and/or it was murder with extreme atrocity or cruelty. To find the defendant guilty on any of these theories of murder, you must be unanimous. That is, all of the deliberating jurors must agree that the Commonwealth has met its burden of proving every required element of that theory beyond a reasonable doubt. You should check the appropriate box or boxes on the verdict slip as to each theory of which you agree unanimously. And I'll go over a little bit later the verdict slip and how that is going to be handled. Now, so if you're unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt either of these theories of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. So I'm going to begin by instructing you on the elements and the additional requirements of proof for each of these theories of murder in the first degree. And then I'll instruct you on murder in the second degree. All right. So number 1, I'll first define the elements of murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following elements. 1, the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. 2, the defendant intended to kill Cora Clancy, Dawson Clancy, and/or Callan Clancy. That is, the defendant consciously and purposefully intended to cause Cora Clancy's, Dawson Clancy's, and/or Callan Clancy's death. And 3, that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. I'll now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Cora Dawson and/or Callan Clancy. A defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended to kill Cora Clancy, Dawson Clancy, and/or Callan Clancy. That is, the defendant consciously and purposefully intended to cause the death. The third element is that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even seconds. The key is the sequence of the thought process. And it would be first, the consideration whether to kill, second, the decision to kill, and third, the killing arising from that decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then to decide to do it. In deciding whether the defendant intended to kill the deceased and whether she formed that intent with deliberate premeditation, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of prescription drugs. A defendant may form the required intent and act with deliberate premeditation even if she suffered from a mental impairment or consumed prescription drugs, but you may consider that evidence. Now, I want to talk about the second theory of first-degree murder, which is murder with extreme atrocity or cruelty. Now, you shall consider this theory of murder in the first degree regardless of whether or not you find that the Commonwealth has proved murder in the first degree with deliberate premeditation, which I just discussed. To prove the defendant guilty of murder with extreme atrocity or cruelty, the Commonwealth must prove the following elements beyond a reasonable doubt. 1, that the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. Second element, the defendant either A, intended to kill Cora, Dawson, and/or Callan Clancy, B, she intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The third element was that the killing was committed with extreme atrocity and cruelty. Extreme atrocity or cruelty, I'm sorry. I'll now discuss each of these requirements in more detail. The first element to this theory is that the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death without which death would not have occurred. The second element is about the defendant's intent, which the Commonwealth must prove in at least one of 3 ways. These are that the defendant, A, intended to kill Cora, Dawson, and/or Callan Clancy, or B, intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, to this intent element, the Commonwealth satisfies its burden if it proves the defendant's intent beyond a reasonable doubt in any one of those 3 ways. The first way of proving intent, that the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation, which I discussed a few minutes ago. The second and third ways of proving intent are different from any element of murder in the first degree with deliberate premeditation. So, the second way is that the defendant intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy. Grievous bodily harm means severe injury to the body. The third way to prove this is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you to understand how to analyze this third way of proving the defendant's intent. You must first determine whether the defendant intended to perform the act that caused the death. So if you find that the defendant intended to perform the act, then you must determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether under the circumstances known to the defendant, a reasonable person would have known that the act created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant suffered from mental impairment or was affected by her consumption of prescription drugs. A defendant may have the requisite intent even if she suffered from a mental impairment or consumed drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the third element in this theory is that the killing was committed with extreme atrocity or cruelty. Extreme atrocity means an act that is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means that the defendant caused the person's death by a method that surpassed the cruelty inherent in the taking of a human life. You must determine whether the method or means of killing is so shocking as to amount to murder with extreme atrocity or cruelty. The inquiry focuses on the defendant's actions in terms of the manner and means of inflicting death and on the resulting effect on the deceased. In deciding whether the Commonwealth has proved beyond a reasonable doubt that the defendant caused the death with extreme atrocity or cruelty, you must consider the following factors. 1, whether the defendant was indifferent to or took pleasure in the suffering of the deceased. 2, whether the defendant's method or means of killing was reasonably likely to substantially increase or prolong the conscious suffering of the deceased. Or 3, whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person. In considering whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person, you may consider A, the extent of the injuries to the deceased, B, the number of blows delivered, C, the manner, degree, and severity of the force used, and D, the nature of the weapon, instrument, or method used. You cannot make a finding of extreme atrocity or cruelty unless it is based on one or more of the factors that I just listed. You may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs in determining whether the Commonwealth has proved beyond a reasonable doubt that the defendant committed the killings with extreme atrocity or cruelty. A defendant may have committed the killing with extreme atrocity or cruelty even if she suffered from a mental impairment or consumed prescription drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now I want to talk about murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, that the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. 2, that the defendant, A, intended to kill Cora Clancy, Dawson Clancy, and/or Callan Clancy, or B, intended to cause grievous bodily harm to Cora Clancy, Dawson Clancy, and/or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The requirements of proof for murder in the second degree are the same as for murder in the first degree with extreme atrocity or cruelty, but without the element that the killing was committed with extreme atrocity. All right? And I discussed those elements earlier when I discussed the charge or the theory of first-degree murder committed with extreme atrocity or cruelty. So they're listed in that other section. All right, now, I want to talk about manslaughter. If you find that the Commonwealth has not proven the charges of first-degree or second-degree murder, you shall consider the lesser offense of manslaughter. Now, manslaughter is an unlawful killing unintentionally caused by wanton or reckless conduct. Wanton or reckless conduct is intentional conduct that creates a high degree of likelihood that substantial harm will result to another person. An omission or failure to act may constitute wanton or reckless conduct only where the defendant has a duty to act. To prove that the defendant is guilty of manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. One, that the defendant caused the death of Cora, Dawson, and/or Callan Clancy. Two, that the defendant intended the conduct that caused the death of Cora, Dawson, and/or Callan Clancy. And three, that the defendant's conduct was wanton or reckless. I'll now discuss each element in more detail. The first element is that the defendant caused the death of Cora, Dawson, and/or Callan Clancy. As I've said before, the defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. And the third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another that a person undertakes with indifference to or disregard the consequences of such conduct. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if the defendant did not realize the grave risk of harm to another, however, the act constitutes wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized that the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that reasonably careful persons would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I've defined that term. So in deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of prescription drugs. A defendant may have the requisite knowledge even if she suffered from a mental impairment or consumed prescription drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. All right? So that's my instructions on the specific elements of the charges in this case. So at this point, I'm going to ask the attorneys to deliver their closing arguments. I just want to remind you, as important as they are, the closing arguments are not evidence. All right? And I'll go over that a little bit later, but I just wanted to remind you that. And so after we go through the closing arguments, I'll come back and give you the balance of my instructions on the law. All right. And so, counsel?
about 5 weeks ago that we met like this, and I indicated to you that thank you for incredible service. That, all of us mean that sincerely. You took literally more than a month out of your lives and sat here attentively, incredible, through some of the toughest, most gut-wrenching things that any person can be subjected to. And I think I indicated that, sadly, jurors carry this trauma with them for years. And the service that you have performed, I have never seen before. You have listened to evidence. You have been fair. You have been objective. You've listened to the judge's instructions, and you've carried them into your heart, consistent with your oath, which is a very, very solemn oath. Passed between government and Lindsay, who has placed herself on her country, which country you are, as a jury of her peers. When you consider what's at stake here in the sense of what we've been dealing with, Cora, Dawson, Callan. She knows loss. And that's why we think of Cora, Dawson, Callan. For a minute. They are the victims of this case. They are the victims of the horrible, horrific act that has been laid at your feet as jurors to decide whether or not Lindsay is guilty. Beyond a reasonable doubt, as His Honor instructed you and will instruct you, what that means, that standard of proof that we as citizens in this country are so blessed to have, proof beyond a reasonable doubt before the government charges any citizen with a crime. I don't care how many cops you have in here, how many DAs are sitting here, how many people are sitting in the front row, and they're all going to sit there and be proud of this prosecution. I told you in the opening statement that this is a prosecution that has ripped the soul out of this girl. This is what they had. This is their family. How does this turn into this? How? Because of the damn medicine and the lousy medical care that she got. You can troop as many paid experts as you want to come in here and tell a jury, oh, well, she didn't say that she heard voices inside her head. She said she heard voices from outside her head. She said she was making chicken McNuggets. She wasn't making chicken McNuggets. She said something as I think and I muse and I try real hard to tell you what my opinion is, that this woman was acting in her right mind when these children were killed. So, when you consider the evidence in this case, you consider the person who is in front of you, who is the defendant, as the government refers to her, and as His Honor will than likely tell you, even though a person is a defendant in our system of justice, you don't have to defend against anything, the government has the burden of proof. When the DA decides to charge someone with a crime, he has the burden of proof. His assistants have the burden of proof to prove, number one, that Lindsay is guilty of this offense beyond a reasonable doubt, and then prove, number two, that Lindsay, at the time, killed her children, was not suffering from a mental disease or defect that caused her to have a lack of substantial capacity to appreciate, to know, to realize that what was being done while she was in a psychosis. But we'll laugh about that. It's just another woman. I guess it's just going to make an excuse. She's depressed. GAD, general anxiety. Give her a couple of pills, she'll be all right. You know from looking at the objective evidence in this case, this young lady, believe me, I don't have many clients like that. This young lady did nothing wrong in her life. She was a nurse, a daughter, a wife, and a darn good mother. You can see from the objective evidence, you can see, and you'll have all the exhibits for you to look at, and you can see by looking at these photographs, which you will have in the jury room. You can see the Facebook postings. You can see what she indicates about, for example, I just randomly grabbed this one, a son, my prince, that they would have you think she killed him first, cruelly, because she didn't like him. That is repulsive. So she's living real life with Pat, her kids, having a great time that summer. Life is good. She had to go back to work. In an opening statement, I told you, I said, watch the evidence. Watch the manipulation. Because that's what this case was built upon originally, and how it developed as the case progressed until it's in front of you. And how does that happen? Well, in the very beginning, going all the way back to when the first 911 call that you had to suffer through was made, you could hear in the voice, Pat Clancy, the horror, what he had obviously experienced. You can see from the evidence that's before you the injuries that she suffered. You will have in the jury room the exhibits that indicated the extent of the injuries from, I don't have to go through all of them, the extent of the injuries to slitting her throat, to slashing her wrists, throwing herself out a window, blood all over the bedroom floor, window open, screen slashed. Oh no, the screen wasn't slashed, my bad. That's what she thought. It's called a delusion. She was in a psychosis when she thought that. Probably right here, sitting here, believes that she slashed the screen. She didn't. It's objective evidence. And why did we spend almost a week showing you the extent and the severity of that suicide attempt? The reason that we had to do that is because they were arguing that it was a fake, dinky little cuts, no bleeding. She didn't mean to kill herself. She's just going to throw herself out the window, I guess, and slide down the house. Remember that one? Hanging off of the window, sliding down the house, and Lindsay screwed up. and she hurt herself bad. You know that's not what happened. You know that she made, the testimony of Dr. Velkovich, that she made a very, very significant suicide effort, slashing her wrist, slitting her throat. And isn't it interesting when you consider objective evidence? Googling slitting a throat, Googling suicide, Googling drugs, Googling side effects, Googling ketamine treatments, Googling all of these drugs, Googling the effects of Tufts medications, lorazepam, sertraline, hydroxyzine, lorazepam, buspirone, trazodone, fluoxetine, zolpidem, myrtazine, clonazepam, quetiapine, diazepam, quetiapine. It goes on and on and on and on and on. You have the chat, you have the descriptions to see. And obviously, she wasn't consuming all of these at the same time, because one thing this kid did was try to do what she was supposed to do. She took the drugs as she was told to take them. She was religious in her obligations to take care of her health. She went to Dr. Tufts when she was a young lady living in her house with her husband and her babies, respected nurse, wife, friend, mother. Should have kept drinking, huh? That was a big deal, wasn't it? Remember that? We're just going to assassinate this young lady in every which way we can. Remember that evidence? I was concerned. She was drinking 5 drinks a day. She was worried about, you heard the evidence up to 2019. What are they talking about? She wasn't drinking while she had her kids. She wasn't drinking while she's breastfeeding. She would have a couple of beers with her friends. That's bad. We put that over in the bad pile. Right here. We spent all that time showing through Dr. Laposada's testimony that this was a legitimate, dreadful, horrific suicide attempt. You think about this beautiful young girl throwing herself out a window. That's a quarter. I don't know if you ever played pool. I challenge you to tell this jury why we spent a week showing that she committed, as your witnesses
Counsel, address the jury, please.
said, their witnesses, serious suicide attempt. Remember that? Tried to kill herself. So now they'll back off on that, and they'll agree. A serious suicide attempt. That's why I say, watch the evidence. Watch the manipulation. Remember the argument with the bands. She took the bands out of the bag, put the gloves on, talks to Dr. Laposada on the Zoom, slams the bands down out of the paper bag, does the movement of the bands and yells at Laposada and says, wrapped. They were just wrapped. They weren't knotted, because you gotta get Lindsay tightening the band, right? You gotta hold it. You gotta hold it for a minute. You gotta hold it for 2 minutes, 3 minutes, 4 minutes. That's why she needed the bands not knotted. And then she said, it's like this. And they sprang open. Remember that? Dr. Laposada said, yeah, I saw what you did. And she walked away like if the glove won't fit moment. Quarter number 2. What did Patrick Clancy testify to? You heard his testimony. He indicated clearly, unequivocally, they were knotted around the necks of those children, to the point where he had to struggle And it's your memory, not mine. If I say something you don't recall, forget it. It's what you remember the evidence to be. But clearly, I would suggest, he struggled to get it off of Dawson's over his head. And a police officer saw through the window. This is horrific stuff. But it's objective, and it shows the manipulation. This government, this prosecution is a mess. They would take their evidence and argue to you that she did not tie a knot and walk away, because as Dr. Laposada said, you're talking about 4 or 5 seconds, so somebody passes out. No, they gotta have the 4 minutes, and that's not what the evidence shows, is it? So, as we move on, Lindsay's in the hospital. And this whole thing about conversations, and she's talking to people, and the kids are in the basement, her throat was crushed. You heard the 911 tape. You draw the inference, whether or not there's a conversation about where the children are. I tried to kill myself, the kids are in the basement, all that. You determine whether or not that was something that could be discerned. And the police investigation, because as His Honor indicates, there are two things here. Number one, proof beyond a reasonable doubt that she's guilty, and number two, proof beyond a reasonable doubt that she was not suffering from a disease or defect, as His Honor instructed you at the time of these killings. Those are the two things they have to prove. And when the police charge somebody with a criminal offense, they have an obligation to investigate. At the end of the day, when you're talking about, well, we've got the charges are before the court, you can sit there in the court, you can feel proud of yourself. Did you do a good investigation? Do you even know what this, you'll see the photograph of the cup and the powder. What is it? They don't even analyze it. Did they take pictures? Did they analyze? Did they test the blood? Lousy investigation in this case. Well, that's okay, because she was guilty, and they put her in the hospital, and she's the evil woman that killed the 3 innocent kids. And they're going to stand there while she's chained to the bed, paralyzed. You heard testimony from Dr. Zeisel. They weren't little fluffy cuffs that were securing her to the bed. They were handcuffs, not the medical treatment. Medical treatment would be, like restraints, so you don't do whatever, pull lines out and things. We're talking about when the big men were in there with their guns and their badges, and they're sitting outside the door, and they're going to make sure that Lindsay Clancy, paralyzed, chained to the bed, doesn't get up and run away from the hospital, I guess. And they just have to suffer their way through. I guess I worked 8 hours. I had another shift I had to work that night. This is the treatment. And what's important about that is what kind of treatment did this young lady get from the healthcare providers? Remember Meg Collins? She came in this court, Meg, you might remember. Tall woman, short blonde hair, squared away. Unbelievable. Unbelievable. She was not only a nurse taking care of her in the hospital, she advocated for her. She stood up for her patient. She protected her. During the pandemic, you know that Meg Collins was in that emergency room when half of us were hiding at home behind our computers, hoping that we're not going to die in a week, drinking our Chardonnay at 11 o'clock in the morning. Meg Collins was in a hospital, treating people and advocating for them. That's an example of what nursing is all about. Not having attitude, not treating somebody like they're to be disdained. And what's even worse, she comes out of a coma. She is intubated. She has had major, major surgery of her broken, crushed spine, vertebrae, rib, thyroid. Massive, not my words, medical records, massive testimony, blood transfusion for the blood loss. And when someone, you've heard evidence, comes out of surgery, they are delusional. You've had anesthesia. You've had think about having a tooth pulled. Think about the trauma that somebody has when they're in a hospital bed laying there paralyzed, unable to feel the lower half of their body, but able to feel with the meds and the pain medication and everything else, the damage to the spine. And then the hospital has a meeting. Remember the other doctor, I think it was Dr. Shah, the Indian woman? Wicked impressive. She was amazing. She had the facts. She was able to tell you exactly what she observed. She was able to tell you what they were doing to treat Lindsay. She treated her like a human being. She was a damn good doctor. Came in here and told you all of her observations about her and told you one of the things that ultimately that they were concerned about is they had to have this big confabulation about, we're going to take her off the, the healthcare process. They had to have lawyers. They had to have people there. They had to have her signing documents. They had to determine whether or not she was going to be signing something to have her parents take over because Pat was not going to be responsible for her care. Lawyers, cops, handcuffs. Do I need a lawyer? Write that down. Where are you? You're out there somewhere. Write that down. Boy, she wanted a lawyer. That's a bad thing. Must be guilty. Let's put that in the guilty pile. That's why she said that, in a delirious state, dealing with all of these people about that issue. But what's even more nefarious, as you think about it, as I said, your eye on the ball because of the manipulation. Paul Zeisel, big deal. I'm friends with the guy. You heard evidence that I called him. I was with Pat a night or two after this incident in the bedroom with all the blood. I was with Pat taking evidence that the police didn't even see in their thorough investigation. And I was able, as you know now, certainly, to grab this. Why wouldn't the police have grabbed this? They're all empty. You can see when they were prescribed. You can see what they are. You can see what she took. You read the testimony. It's tough to take a handful of pills. Remember the guy saying that yesterday? Tough to take a handful of pills. Well, no. They were crushed. Oh, shit, they were crushed. Okay. Where's the residue? Where's the crusher? Where's anything? Doesn't matter. Doesn't matter. Great investigation, guys. So you have a situation where they leave this behind. They don't even look at it. One of them, and again, your memory, not mine, one of them testifies, well, they might have looked at it and saw it and just didn't seize it. Seriously? They go down to the kitchen, they seized every pill bottle that was in the cabinet, along with the books. And speaking of books, one of the things that they found, smoking gun. Good moms have scary thoughts. Hallelujah. Put that in the guilty pile. We're going to put this in a plastic bag. We're going to show it to a jury so they know that this young lady had scary thoughts. Turns out that Jolada gave it to her. So you have this evidence. You have evidence of sleep aids. You have evidence in the bag, because obviously this stuff was just thrown in there. It wasn't in a bag when I saw it inside this thing here, and we seized it, and we held it for 3.5 years. Anybody care about it? No. You had evidence that the police knew that I had it. They could have it, they could look at it, they could analyze it, do whatever they wanted. They didn't have to. This here, you heard evidence. This is a little wish jar that they bought on their honeymoon in Hawaii many years prior to even having kids. And when you look inside it, you see that there's all sorts of little folded up pieces of paper. Some of them are dated, some of them aren't. They go all the way back to 2017, 2018, 20. And they reference her wishes to have healthy kids, her wishes for her kids to be successful, her wishes to have a good birth. Second time around, hoping for a good birth, worrying about the child with the, I forget, where they rub the thing like. This woman lived for her kids until she had the pleasure running into Dr. Tufts of her 2 months experience. And after she ran into Dr. Tufts, it was not a wonderful life anymore. And what did Dr. Tufts do? And everybody laughs at me. I said the television. Okay, I know it's a telemedical thing on your telephone or on a Zoom. Take more pills. You have the medical records. You heard the testimony. You know her concerns. You know her fears. Does this seem like a young lady that didn't care and wanted to score more drugs off somebody? That's another repulsive allegation. I think the evidence is pretty clear. There's no basis for that at all. She was scared. September into October of 22, young, vibrant, hardworking, you've heard all this, not my words, witnesses' words, holding goals for herself. Hardworking nurse, hardworking mother, would take the kids to the Kingsbury Club. That's another thing. Sounds pretty snooty, doesn't it? Oh, they're at the Kingsbury Club. It's a swimming pool and a place where you can exercise. Watch the manipulation. Because now you've got a situation where you've got manipulation with the Kingsbury Club, you've got manipulation with these other items here, and you've also got manipulation of Paul Zeisel told Lindsay what to say. Say that you're hearing voices. Think about how ugly that is. Because you know, beyond a reasonable doubt, even though we don't have any proof, we have no burden. You heard from Sheila. Remember Sheila, the woman that's the reverend or whatever, she's the chaplain at the Brigham and Women's Hospital. She didn't know Lindsay from anybody that night when she came in all broken up. And she told you, continue. She was there when Lindsay came out of, was extubated. She was there when Lindsay was going through her treatments. She was there for 8 days before Paul Zeisel even knew Lindsay existed. But they would be in here telling you that Lindsay saw the psychologist because the lawyer went and got the psychologist to go and speak to her. And then you have these guys here, the cops. They're having meetings, talking about it. They're talking about it. Must have been the shrink. Must have been the psychologist. Must have been Zeisel. He's the guy that told her what to say, and he did not. How can you ruin a man's reputation with the career that he has had and still has, thankfully, to put him in a position where he tells a broken young woman who is vilified by our society for killing her 3 children, that he goes in the hospital and tells her to say she heard voices. Disgusting. So now you know that she told Sheila first that she heard voices. Command hallucinations. She didn't say command hallucinations. I heard voices. It was a male voice. Told me, you had these other guys that came in. The government's rebuttal witnesses. Very, very impressive. Very, very impressive. The first 2, Mac, put him aside. You've got the other doctor as well. So Mac is, why he was freaked out when I asked him where he stayed, and the other guy looked at me like his eyes were bugging. Why did I ask where he stayed? Whatever. Point is, they don't see her for years. Years. And why? The other guy, Halburn, I think it was Halburn, he had to wait until maybe it was the last name, I forget. They had to process his payment from the DA's office through the school. Who cares? If you have an obligation to try and be objective, to try and even look as though you're competent and objective, why would you wait for so long? Why would you go with another guy? Why would you take this young lady and have her in a room and question her, one right after the other? Wouldn't you like to sit there and be questioned by Dr. Mack? Boy, that'd be an experience for 3 hours, 4 hours. And the other guy is going to pepper his questions at her as well between that period. And the next day, she can take tests and then go back at it again with Mack and with Halburn. And she was cooperative. She was pleasant. She was friendly. She answered the questions, and she owned what she did. Huh? She never ran from anything. She's gone through evaluation after evaluation after evaluation, recorded. You'll have the video to look at as they're questioning her, as she's sitting there in her wheelchair, hour after hour after hour, 3 years after this incident, but that's okay. They're busy. Paul Zeisel was there, literally, in Brigham and Women's, because I called him. Because I was asked to represent this young lady. You heard evidence. I saw her in the hospital. I saw her laying in the bed broken. I saw her laying in the bed practically dead. I reached out to Dr. Zeisel, and I asked him, please, can you talk to this woman? Concerned, as he testified, for her mental well-being. What kind of demons, what kind of horror was in her mind as she lay there paralyzed and hurting and medicated, swollen, tubes, pops, chains. He went and talked to her. Big deal. I asked him to go. You judge the credibility of a person. Did Paul Zeisel have the ring of truth when he told you that he's there out of humane feeling to try to help this young lady? And he's been by her side for 3.5 years. Same thing as Sheila. Why would Sheila, for all this time, visit with Lindsay as she testified at the Tewksbury Hospital? She's not getting paid. She's not a hired gun. She's not somebody that's coming in to say something at my request. She loves Lindsay. He's a good kid. He's a beautiful soul. So you have Zeisel that has been with her all that time. You've got Sheila who's been with her all that time. You've got evidence that her mom and dad who lived in Connecticut come up and they stay and they visit with her and that they sit with her, and God forbid they actually sometimes have dinner. Remember that? They get the Tewksbury records. Boy, there's a good score. Let's go through the Tewksbury records and see what she's doing on the anniversary of the deaths. How about on their birthdays? Can you see them sitting there going through the medical records? Okay, doctor, what did she do then? She propelled herself down the hallway, met with her parents, laughed, had dinner, watched TV, talked on the telephone. God forbid. She's not curled up in the fetal position, wailing, self-flagellating constantly for 3.5 years. She's acting like a human being trying to exist. But they go through the records and they want to get those dates and use them against her. Manipulation. And then you consider we're 3 weeks away from a trial. And the guy yesterday that's looking up to the heavens while he's testifying, Caesar, tells you that he wanted to establish a rapport. Can you imagine? You know that you're 3 weeks away from your murder trial, and you know that this is doctor number 3 who's been hired by the government to come in and evaluate you and testify against you, and he's going to establish a rapport. There is no rapport, but yet she was cooperative, she was friendly. Interestingly enough, just like the treating doctors don't talk to each other, they don't communicate with each other, they don't have access to medical records, she signs the HIPAA forms. They don't know what her records are, but they know for sure what Dr. Resnick had in his report. They know for sure what Dr. Zeisel had in his report. They know for sure what Meg Spinelli had in her report, and they incorporate that into their report. But then you have the MMPI and the other psychological tests that were administered to her on the second day of the Mac Heilbrunn team interviewing, interrogating, questioning her. She passes the MMPI. Testimony is presented. She answered the MMPI honestly. And they're pertaining to state of mind. They're pertaining to questions about what occurred. They're questioning this young lady as to what her state of mind was then, in the middle, and now. And she didn't lie. She didn't malinga. She didn't exaggerate, and more importantly, if anything, she minimizes. But she certainly was off the chart on the suicide scale. And then you have testimony from Dr. Resnick, Dr. Zeisel, Dr. Conde. And they were paid for their testimony. We're all paid, like I said, not the jury so much, but the judge, myself, Chrissy, everybody gets paid. These doctors came in and testified. Phil Resnick, the man is something out of a scary movie. He has the world record of investigating, examining, and treating people in psychosis that kill their children, filicide. He has a world-renowned record for checking fakers to see if a person is malingering. Their doctor agreed that his article on Voices is a leading article with research in the world. Their doctor agreed that he, Bill Resnick, is an expert on malingering. You heard him testify by Zoom because he had surgery. But he showed up by Zoom and testified that, again, 4 months after this incident, he met with Lindsay, he evaluated Lindsay, compared, looked at all the records, just like all the rest of them. Everyone says they looked at all the records, the police reports, grand jury minutes, everything else. He indicates clearly, in his opinion, that she was in a state of psychosis at the time of this death, ×3. Has any of the government doctors rebutted that? One of them, Heilbrunn, said it's possible either way. That's not proof beyond a reasonable doubt. The other one, Mac, you can accept his testimony if you wish, but I suggest that you probably won't. And then you're left with the doctor yesterday, who didn't even know what killing during the course of the psychosis was, and when I was questioning him about it, he agreed, and I said, don't just agree with me. You're just agreeing with me because I said that? And he basically said, yeah. What kind of expert testimony is this? It's a mess. But the government uses them to try to rebut a man like Phil Resnick, who tells you that she was suffering from a horrific mental disease and defect at the time of the killing of her beautiful children. Why? The how? And the fact that under the law, as His Honor has given you, she's not criminally responsible. And the burden is on them, right here. Prove to you that at the time of the killing, as Dr. Resnick says, that she was suffering from a disease or defect, as Dr. Zeisel said, that she was suffering from a disease or defect, as Dr. Conde said, she was suffering from a disease or defect, and Conde took you down the road of all of these medications as a psychopharmacologist, as a doctor that specializes in prescription medications. And you got the evidence, so you're able to look at that and determine, see what the side effects are, what she was complaining of, and look at her records. I mean, they have really turned her inside out. I mean, they've got every single text, every single email, every single picture, everything that she did in college. Oh, that's another thing. She lied, according to the guy yesterday that testified, she lied to Pat about being on Prozac. They were dating for 3 months. She's living in Boston. She meets this kid. She thinks that she might like him, and they're dating. Oh, excuse me, before you go out with me, let me tell you that about a year ago when I was studying for my exams, because I'm nervous about talking in public, I got on Prozac. Seriously? That's what the government is arguing in this case. You're going to have this journal, which talks about her being, this is how controlling she was, manipulation. In the opening statement, you may recall that the district attorney said that she was a hard-charging, manipulating woman that was controlling, and everything in their life was controlled, and she ran it to the water, to the carrots, to the beets. You look in this book, and as you might recall, Ms. Rossi testified, when asked, did you feel that she was being controlling of you? Because she says, for example, Monday, 10:24, Callan, put down for a nap. Hopefully we'll nap for 2 hours. If he wakes shortly, let him resettle himself. Bottle when he wakes up. Then it goes on and on. Make salad, romaine lettuce. He likes peppers, broccoli. Cut the sweet potatoes in chunks. Thank you, with the heart. Another good score. You look at her journals that she took. You'll see, as you go along, in the dates that she's recording in these journals, she's talking about the drugs that she was prescribed. And look at the first page. Look at how detailed. Dates, how she felt, 10 milligrams Prozac, and it goes on like that, goes on through November into December. December 9th, 10th, 11th. Horrible intrusive thoughts. Horrible thoughts in the AM. Horrible thoughts. Horrible thoughts. No motivation. And then finally, horrible thoughts, no motivation, deeply depressed. Then, that's around the time she went to Women and Infants Hospital, right? Looking for help. Look at this. As she runs into January, there's nothing other than little chicken scratches because her mind was gone. In January, as she's on these drugs and she's suffering from what you've heard is postpartum depression that can lead to postpartum psychosis, and you have these men coming in here that don't even know psychosis from schizophrenia as experts, telling you that if a woman doesn't have these symptoms, like it's a disease, symptoms of postpartum depression within 4 weeks, that's it. Lights out. You're not a person that can be considered. You're not a real person for purposes of postpartum depression and or postpartum psychosis. Well, I suggest that he's wrong. I suggest the second guy's wrong and the third guy. Well, actually, I don't even know. It's your memory. If the gentleman, Mac, even knew, I think he said 4 weeks. It can go up to a year or longer. But we don't really know because you heard the evidence. There's no evidence. There's nothing in the DSM, but that's the Bible. God forbid you should go to Europe. You should look at the World Health Organization records. You should look at the way they treat pregnant women that have problems with their children. No, we're the most advanced country in the world. But we still have doctors that come into court on a murder trial and talk about 4-week cutoff on something that they don't even know exists. They've never treated it. They've never written about it. You have terrorism experts. You have an expert that comes in and talks about his focus and his interests, and it's about juveniles and drugs. And like I said, kids that like to drink and smoke weed. Those are the experts, quote unquote, to support their burden to prove beyond a reasonable doubt that Lindsay was not suffering from a disease or defect at the time she killed her children. You all remember this. October. This is not an evidence, it's marked for identification, it's too big, so. But basically it shows clearly and unequivocally the depths of despair that this young kid was in, trying to raise 3 kids, trying to be a wife, ready to go back to work. Did anyone say that she was just lazy or just didn't want to go back to work? That's manipulation. They're arguing. She didn't want to go back to work. She didn't want to go back to work because she didn't want to leave her kids, especially Callan, because she loved her children, her life. Manipulation. And when you consider the journals, I don't know, you ever watched the movie there, The Shining, with Jack Nicholson? Remember the scene when he's sitting there in a state of complete psychosis, and he's writing a book and he's typing, and the wife finds the book and opens it up and looks at it and says, all work and no play makes Jack a dull boy. All work and no play makes Jack a dull boy. Repeated after repeated after repeated. And he says, do you like it? You look at the records of her Googling drugs. You look at how many times, how many hours of the night in the afternoon she's looking this stuff up, in between taking care of the family, in between all of the stuff that was going on with visiting doctors, seeing doctors, going to Rhode Island, being told, no, we can't help you, calling a suicide hotline, we can't help you, calling another suicide hotline, we can't help you. My God, what does she have to do? She was reaching out for help, and she was not getting it. She turns herself in to McLean Hospital. You saw the doctor, nice woman. She's testifying. She didn't know. I suggest to you that she didn't know hardly anything, let alone psychosis involving a young lady like her going through what she was going through. The government bears the burden of proof beyond a reasonable doubt. They bring, for example, Ian Whiffen. The guy, you might remember him, was the guy that's, I guess he developed or helped develop Celebrate. What you got when you look at the records, you don't measure on an Apple Watch. Well, I shouldn't say Apple Watch because we know that they didn't have the Apple Watch, but on a cell phone. You don't measure going down the stairs. You measure stair climbing, right? That's what the testimony was. And there were 3 stairs that were climbed. Okay. The last record is 5:38. At 5:38 p.m., we went through that on cross. What happens to the phone? Don't know. It was on the bed. Was it dropped on the bed and it left there for 20 minutes? She could have been anywhere in the house during all that period of time, right? Right? You've got a compressed period of time that Patrick leaves to go to the restaurant to pick up the CV, and you heard the guy yesterday say, and then she sent him off to go to CVS. It's on the way. It's on the way. She didn't want him out of the house long. She was in distress. She wanted him home to help with the bathing, to help with the kids, to help putting them to bed. How long is he going to be gone? She Googles it. Is that something that is so nefarious? You'd think that that goes right along the line with the book about good mothers having bad thoughts. My God, she actually Googled the time frame that Patrick would take to go to 3B and pick up the food and then leave and stop at CVS on the way. So I guess the government is suggesting she's not in a psychosis. So she's Googling Miralax because the doctor earlier that day told her that the baby Cora needed Miralax. Why would she do that? Because remember the government's opening when they told you she wasn't suffering from the psychosis. She was a woman that didn't want to live a life anymore, wasn't happy being a mother, didn't want to live that life. So she's going to kill her kids and hopefully throw herself out the window and not paralyze herself, and then she could run off into the sunset, I guess. That's what their theory was. Along with the fact that it wasn't a real good suicide, it was fake. Well, now we know, don't we? the mess that this young lady was in her brain, my brain is being damaged. I will never be better. That's the evidence. That's the evidence that we have in this case. Burden of proof is on them to prove to you that at the time that she killed these 3 beautiful kids, that she just wanted to move on with her life. And I suggest to you, just as there's no chicken nugget residue, and then when you look at those photographs, there's a slice of a cucumber, there's a slice of a carrot, there's no chicken nuggets in that bowl. Patrick wouldn't know what the kids were eating. She was the one that would cook their dinner. She was in the refrigerator, but the guy yesterday is like, oh, no. Patrick said that the child was eating the chicken McNuggets in the bowl. No, she was getting food out for the 2 kids, not the little baby, 2 kids for dinner. There's no evidence that she's lying. There's no evidence that she's malingering. And finally, you remember there was a big deal about whether or not the voices are within the head or whether or not they're outside of the head. Dr. Resnick's article with the largest research on voices malingering in the world indicates that 38% of almost 1,000 people that were examined report voices from inside their head, and it stops. You're going to buy that guy yesterday? He doesn't know what he's talking about. This young lady is not guilty of the killing of her children because she was suffering from a disease and defect, as His Honor instructed you. And they're not going to be able to prove otherwise. And it's their burden, not ours. Thank you.
All right, Como.
There's no dispute that Lindsay Clancy was suffering from mental illness and that she tried to kill herself. There's no dispute about that. All of the evidence that you've heard, even the experts that the Commonwealth put before you, say that she was suffering from mental illness and she tried to kill herself. That's not the issue in this trial. The issue is whether, at the time she killed Cora, Dawson, and Callan, she knew the difference between right and wrong, and whether she could conform her behavior to the requirements of the law. This case is not about our mental health system or how it treats women or what's in the DSM-5 and what's not. That's a distraction to get you angry and passionate about an important issue, but an issue that's not on trial here. What's on trial here, what the issue is here, is what Lindsay Clancy did the night of January 24th, 2023, and what her mental state was at the time. And you can use her psychological history and records, the treatment records, to look at both before and after she killed the kids, to look at how she got to that point, what her thought process was, what her motivation was. But it's not the system or the DSM or any of that that caused her to strangle her kids. In fact, she had more access to treatment and care and support than a lot of people do. She had health insurance that covered multiple doctors, multiple specialty programs, treatment at South Shore, at Mass General, her stay at McLean. She had prescription coverage to cover the different trials she went through. She had support at home. She had 18 weeks of maternity leave with the opportunity to extend that as much as she needed, which is excellent, which is what all women should have. But she had that. She had support from both sides of her family, hers and Patrick's. The 2 older kids, Cora and Dawson, were in preschool 3.5 days a week. And she had the nanny, Elaine, who helped with Callan 3 mornings a week. And she also helped her with housework and with food prep. This wasn't a woman suffering from a lack of care, a lack of resources. She had an abundance of help, an abundance of care. She had all of that and more. And, you know, this doesn't mean that she wasn't struggling, that she wasn't dealing with mental health issues. She was. She had depression. And whether that's from bipolar or major depressive disorder or postpartum depression, it all boils down to she was depressed, right? And she was trying to deal with that, trying to get help for that. But it wasn't the fault of the providers that she was struggling with this or that she wasn't getting better. They were doing the best they could. You have the records, you heard the testimony. They were doing the best they could with the information she provided them. And that wasn't always accurate information. That wasn't always the full picture. And they were doing the best they could with her level of cooperation and compliance with the plan. Take her medications. You know from the records and from the pill bottles what she was prescribed and how she was supposed to take those medications. And you know from the pill bottles what she actually took. And sometimes those two things didn't align with what she told her providers, what she told Patrick, what she told her mother. You take the Zoloft, for example. The prescription was for one 25 milligram pill a day for 7 days, and then to go up 50 milligrams after 7 days. She told Dr. Tufts that she took the pills as prescribed for 7 days, went up on the 8th day to 50 milligrams, and that's when she had the insomnia and the other side effects and symptoms. She told Patrick that she took the pills for 7 days and they had no effect, so she called Dr. Tufts, who then told her to increase the dose. Well, you know what she told Patrick is not accurate because the pill bottle says, take it for a week and then increase it. That was the plan for the beginning. That wasn't the result of a phone call to Dr. Tufts. And you know what she told Dr. Tufts isn't accurate either because only 7 pills were taken from the bottle. So that leaves you either she took the medication as prescribed, 1 pill a day for 7 days, and then didn't increase it, which she says is what caused the side effects and the insomnia, or what she did was not take it as prescribed. She didn't do it 7 days and ease into it and then increase it. She either missed a dose or increased it early before she was supposed to. Either scenario is not good. She knows as a nurse the importance of following the instructions of your medications. She knows how important it is to follow the plan and do what's on the bottle and do what your provider tells you and to give that accurate information to your provider. She didn't say, I went up to 50 too early. Maybe they could have adjusted that and tried the 25 milligram for longer and eased her into it. But no, she told her that she did what she was told and then went up and had these problems. So you can see that in a lot of the medication she has. You have the pill bottles that were turned in by Patrick, and a lot of them don't even have many pills missing from the bottles. Some of them have none. The Buspar prescription, the first one, there's only 2 pills missing. The second prescription, no pills missing. The Lamictal, she never took those pills at all until the night she tried to kill herself. So there's a lack of compliance there, a lack of follow-through, a lack of communication with her providers about what was happening with her and how she was taking the medications. And defense wants you to believe that this is a woman who's begging for help and willing to do anything and everything her providers tell her to do to get better. And she was asking for help. She was. She wanted help. She wanted to get better. But she wanted to get better on her own terms, doing things her way, the way she thought she should do them. And as a nurse, she knew that's not the right way to approach it. She knew that an accurate medical history, accurate information about your side effects and symptoms, what your thoughts are, that's important for your providers to know. And she didn't do it. And it seems that the reason that she's not necessarily fully compliant, she has this desire to be herself again. She just wants to go back to who she was, and she wants it now. And she doesn't want any side effects. She just wants to be herself again and wants it now. And that's That's understandable. That's relatable to want to get that magic pill that will fix you immediately and you can go back to being yourself. But she knew that's not how it worked. And you know that's what she was thinking, because in the searches on her phone, she's searching for things like, which antidepressant works the fastest? How fast does Wellbutrin work? And she's searching all of these different medications for the side effects and symptoms, some of them that she never even discusses with her doctors. And, again, it's relatable that she wants to get back to where she was, but she had discussions with her providers about how these medications work, and that it takes time for them to get into your system, and it takes time for them to work. She even texted her mother about that, about how she knew that she had to be patient, that it took weeks for the amitriptyline, for example, to get into her system and worked. And she knew all of this, and she couldn't be patient. She couldn't wait. She wanted faster. She even told Dr. Tufts, it's a note in the records, that she knew the problem was that she wasn't focusing on one provider and following one plan. She knew that going from doctor to doctor, practice to practice, South Shore to NGH, to different programs, not the best way to deal with the situation. She said it in her own words to Dr. Tufts, "I need to stick with one provider and stick with one plan to see if it works." And she actually turned down help from at least 2 locations at various points. We talked a lot about the women and infants records, and you don't have to believe what I say about them or the witnesses say about them or defense. You can look at the records themselves. Page 9, it says right there, Patrick was the one who said over-medication was the issue. Not the doctors there, not the people evaluating her. What they put was depression, RO, rule out adverse medication effects. That means they have to look into it to see if medication's a problem. But there's a difference between an adverse effect, a symptom, or a problem with a medication, and being over-medicated, taking too much of a medication or taking too many at one time. There's a difference there. And women and infants never said she was over-medicated. What they also don't do is turn her away. It's not that she went there and they said, "Can't help you, go away." They told her, it's in the records, based on the onset of her symptoms, they weren't sure if it was postpartum or peripartum. They saw she had an issue. They wanted to help her. It says there, we offered her. They offered her 3 programs. They offered her the inpatient medical management program. They offered her a partial hospitalization program for general mental health. And they offered her an outpatient program. It shows they put a lot of thought into that, into offering her this care. When they gave her 3 separate options, considering she's a young mom, maybe she doesn't want to be away from home, but we'll give her the option of being in the hospital and getting her medications right. But we'll also give her the option of the partial hospitalization, where she can, be here during the day and go home to her kids in the evening. And then that third option of being an outpatient and being able to be at home with her kids and come in for appointments. It was very thoughtful of them. It was very well planned out to give her these 3 options. And it's kind of the exact opposite of just turning someone away and saying, "Go away, we can't help you." And her response, "I'm going to talk to my provider about it for guidance." And she goes to Dr. Tufts. She sees Gelada at some point. You look at the records, she never discussed those options with them. She told them that women and infants turned her away and said she didn't qualify for the program. She didn't discuss those 3 programs that they offered her. So basically, they give her this offer of help, 3 different forms of help, and she says, no, doesn't want to do them, and doesn't discuss it with her provider. And also that first time she goes to Mass General, to the emergency room, they offer her a bed at McLean, and she turns it down. She wants help. No one's saying she doesn't want help, but she's making these decisions and doing these things that aren't helping her get help, that are turning away help, because she wants the help in a certain way, in a certain time frame. And, all during this time, between September and December of 2022, she's interacting with friends, with family, teachers, gym staff, the nanny, people at gymnastics, interacting with them in public spaces, in public ways, driving her kids around, all throughout that time, able to know the difference between right and wrong, able to conform her behavior to the law and to the requirements of society, and interacting with others and presenting herself as a functioning adult, a functioning mom. You know that she knew the difference between right and wrong during that time because she had those thoughts at the beginning of December of harming her kids. And she told Patrick and her mother about them. But who she didn't tell is important and very telling. She didn't tell a single provider, not Tufts, not Gelada, not Jennifer McAllister, not Dukes, no one at McLean, no one at MGH, no one at South Shore, didn't tell any of them. And why? Because the police might take away her kids. That's a rational thought, that telling mandated reporters that you're having a thought of harming your kids, that they might be taken away for their safety, that's a rational thought. And it also shows she knew it was a bad thought, a wrong thought, because you don't think someone's going to take your kids away because you're thinking something positive or neutral. It's because it's bad, it's because it's wrong, it's because it's against the law. So she knew that it was wrong. And she was able to conform her behavior to the law because she didn't tell those providers. She went in and met with them and talked about what she was experiencing and talked about her depression. And not only did she not tell them, she lied to them. They asked her, are you having thoughts of harming others? Do you have homicidal ideation? She told Tufts no. She told Gelada no. She told Dukes no. She told Goodhart no. Every day at McLean, she said no. At MGH, she said no. So not only is she hiding it, she's lying about it. She's controlling her behavior. She's controlling the presentation she presents to her providers. And then you get to her being admitted to McLean. You know, up to that point, all of the drugs she's taken from September through December, they weren't given at the same time. The most she ever had at one time was 2 to 3 medications. And usually if it was 3, that third medication was the Benadryl or the hydroxyzine that's like Benadryl, or the Ativan or Valium as needed for anxiety. But most of the time it was 2 medications. And the way they did those medications, you heard from Dr. Satoff, a man who's examined thousands of patients with psychosis, who's treated women with postpartum psychosis, who's treated women who have killed their children, that man who apparently has no expertise. You heard from him that the medication trials were reasonable and rational. She tried a medication, it didn't work, or they had side effects, they stopped the medication. They tried something else. They tried a different combination. And unfortunately, with mental health, there's no blood test or CAT scan or MRI that you can do that says, well, you have bipolar or you have schizophrenia. It unfortunately doesn't work like that. So what the providers have to do is rely on what the patient's telling them. Hope that information's accurate. Rely on what they're observing about the patient and make a diagnosis. And then based on that diagnosis, have a treatment plan. And every patient reacts differently to medication. One patient could do fine on it, the next not. So they have to do that trial and error process, and it's normal, it's typical, it's reasonable. And that's what they did for her. And even if you believe that the number of different medications she took over that time or the combination of those medications affected her negatively, after McLean, they were out of her system. Some of them had been out of her system for months. Zoloft, she stopped in October. Other pills she stopped in November or December. And that last one, the Seroquel, that she really had a bad reaction to, is out of her system. The only medication she's on leaving McLean is trazodone for sleep and Valium for anxiety. And that's it when she leaves there. And why does she leave there? He wants to go to Corey's birthday party. And that's relatable, that's understandable. She wants to be that mom again who can throw her daughter a party and enjoy it. It's completely understandable why she would want to leave, but she also knew she wasn't there. She knew how she was feeling. She knew she was depressed. She knew she needed help. But she wanted to be that mom she was more. And there was nothing McLean could do to keep her there. She said she denied suicidal ideation. She denied homicidal ideation. She said she wasn't hearing voices or seeing anything. They saw the entire time she was there no signs of psychosis. In fact, every doctor she saw, from Tufts in September all the way through Tufts at January 23rd, none of them saw any signs of psychosis ever. So they're all wrong. All these different doctors at all these different practices, they're all collectively together wrong. That doesn't make sense. But she shows when she's leaving McLean, no signs of psychosis. And they even give her a task to do to see if she can manage her mental health outside of the hospital. Make an appointment, pick a doctor, make an appointment. And she does it. She decides on Dr. Tufts. She makes the follow-up appointment. She gets the documentation and gives it to them, showing she can manage her mental health. They have to let her go at that point. She's there voluntarily. There's no grounds to keep her if she's not showing she's a danger to herself or others. So they let her go home. And at home, again, all throughout January, she's showing her ability to know right from wrong and to conform her behavior to the requirements of the law in all the activities she does in January. First, there's the birthday party. She's throwing the birthday party. She's monitoring the kids, making sure, everyone's eating, getting cake, singing happy birthday. You saw her in the video. She appeared happy and smiling, normal. Everyone that interacted with her said seemed a little tired, but okay. The Museum of Science, you have that video. The Museum of Science in Boston can be crowded and overwhelming on a good day. And she's there with 3 kids under 5 with her husband. You see her monitoring them, caring for them, doing the exhibits, showing them what to do with the exhibits. If you watched that video and you didn't know who the Clancy family was, and we asked you, pick out the woman who is depressed, pick out the woman who wants to kill herself, pick out the woman who's about to kill her kids, you couldn't pick her out. She's completely calm. All her behaviors are typical and normal because she's able to control her behavior. She's able to be suicidal and feel those things, but control her behavior, control her thoughts, and present that image to the world. She's able to do it at the Cape Codder as well, similar scenario. She's able to watch the kids when Patrick goes to brunch. She's able to watch the boys when Patrick and Cora go skiing on the 16th. She's able to interact with the Carneys on January 22nd. And yeah, they both initially said she was quiet, but then they both admitted she was always kind of quiet. But she was able to interact with them, chat with them in the kitchen, seemed okay. In between January 7th and January 21st, her mother never comes to the house to intervene. Her sister, a licensed social worker, a mandated reporter, never comes to the house to intervene or help, never makes a report, and they're in contact with her every day, texting with her, calling with her almost every day, and never see any signs that they should be concerned or worried or intervene. And you have those text messages between the defendant and her mom. And her mom, obviously, was very attentive, very caring, asked very pointed questions. How are you doing? How are you sleeping? How are the medications? Obviously, a very concerned, loving mom. How does Lindsay answer? I'm getting a little better. I'm sleeping better. She said the only time her sleep was interrupted is if Cora had a bellyache or one of the kids was up. But she's doing better every day. She's sleeping better. She's feeling better. She still says, I'm not myself. I'm not where I want to be, but she's moving in the right direction. And we have that text from her mom the day she leaves on the 22nd, headed back home, "I'm glad to see you're doing so much better." Now, her mom now wants you to believe that she lied to her, that she wasn't doing better and she was just trying to encourage her. But there are so many things you can say to your daughter who's struggling with mental health other than lie to her if you want to encourage her. You know, "You've got this. Take it day by day. I'm here for you. We're going to get through this." But she wants you to think she lied to her when she said she was doing better. But you know that wasn't a lie. You know that she was doing better, or seemed to be, and that her mom said, "I'm glad you're doing so much better," because Patrick said the same thing. He said she was doing better in January. Every day was better. The 24th was the best day. They had hope because that's what she wanted to show them. The only person during that time that she gave even a little glimpse of maybe she wasn't doing that much better was Dr. Tufts. And she told Dr. Tufts that she was feeling depressed, which is why Dr. Tufts prescribed the 10 milligrams of amitriptyline a day, very low dose. And then she told Dr. Tufts again, still not helping. And so Dr. Tufts raised it to the 20 milligrams. Again, a very low dose, a dose a child could take. And that shows how cautious and conservative Dr. Tufts was being in the treatment of this patient who had had those interactions with medications previously. She was being cautious and conservative and acting with care for the patient by slowly increasing the medication. But even with Dr. Tufts, she still denied having a suicide plan, denied wanting to hurt anyone else, denied voices, denied visual hallucinations, showed no signs of psychosis. All the way up to January 23rd, nothing. And if you look at their journal, you look at this journal that defense counsel showed you, she's very detailed, excuse me, about when she took medication, what she took, the amounts she took, what the effect was for months, starting in October and going all the way up to January. And where it stops, January 18th. Someone who's been so meticulous about everything all the way up to January 18th, and it just stops. It's as if she's decided she's done trying. She's decided that it's too much and she doesn't want to do it anymore. And so she just stops keeping track of the prescriptions. And then we get to January 24th. Everything that happened that day, every person she interacted with, every situation she was in, shows you she knew the difference between right and wrong, and she could conform her behavior to the law. The doctor's appointment first thing in the morning. She's able to drive there. She's able to interact with medical professionals. She's able to seem absolutely fine and normal. And this is a doctor who's treated the kids since Cora was a baby. This is a pediatrician who's known the family and has known Lindsay for almost 5 years. A woman who's trained in recognizing the signs of postpartum depression. She told you she looks for flat affect, she looks for teariness, and some other things that she told you. She saw none of that. She was able to control herself and interact with her in a perfectly normal, concerned mother way. Able to get home from that appointment. She plays with the kids, she takes them outside, she's sending those messages and photos to her mom and to Patrick, basically saying, look, this is a good day. I'm having a good day. Everything's good. I'm getting better. Here's proof. This is what I'm doing. You start to see the planning at about 4 o'clock in the afternoon. And this is on her phone. You can see her search for Miralax, kids Miralax at 4:02. And then a little while later at 4:13, you see her search for takeout from 3V. And then immediately after, she does the Apple Maps search to see how long it takes to get to 3V. Well, defense wants you to believe that, she was checking that because she didn't want him gone for too long. She wanted him home. She was in distress. If you're in distress, don't send him anywhere. Make food at home, have him cook, get delivery, get DoorDash. Go to one of the other restaurants that Patrick mentioned that were 2 minutes down the road. And she didn't have to look up on Apple Maps to see where this restaurant was. You heard from Patrick, they had been there at least 3 times in the months before. She had lived in that area for 4 years. She knew where it was. She knew generally how long it would take to get there. What she needed to know was how long specifically on that night it would take to get there. Because she knew she would have a limited amount of time to do what she wanted to do. And what she had decided to do was to kill the children and then kill herself. And so she needed to know, not generally, but exactly how much time will I have. And then obviously sees that that's not enough time. So then she searches CVS. And not only does she search CVS, she calls them. Calls them and asks them if they have kids' Miralax, and they say no, but they have Pedialax and one other medication. And then she asks, is it in stock? Because she needs to know not only what they have, but is it in stock? Because she's adding to this errand that she's sending Patrick out on. And she has to make sure she's not interrupted. She doesn't want that call at 5:33. She wants him to go to CVS and have the medication there and get it, and then go on to 3V, so she has time to do what she needs to do. So that's why she's calling to see what they have and make sure it's in stock. It's a level of planning there and thinking and decision-making that Dr. Satoff referenced. And then after that, she texts Patrick, you know, it's been a long day, can we do 3V? And he's on board with that. And she's like, okay, check out the menu, let's get on this. And he asks her what she's getting. She tells him the Mediterranean Power Bowl. He says he's getting the pork belly risotto. 5:10 p.m., she's calling that order in. She's talking to the hostess. She gets the order accurate. She is able to answer questions about how she wants her food. She's able to recall and give Patrick's phone number and his name as the person picking up. And then Patrick's leaving to go get the food. And as he's leaving, the kids are in the living room on the couch eating. The defendant's in the doorway near the basement door. And she says to him, oh, by the way, can you go to CVS? Acting like it's this last minute thought, like, oh, by the way, can you get this? And not something that she's been planning for over an hour. She knew about the Pedialax, and she knew about 3D, and she knew all of that before she even asked him about dinner. But it's like, oh, can you go to CVS on your way and get kids Pedialax? And he, of course, is like, sure, I'll get that. And he heads out the door at 5:15. And you know that's the time he leaves, because he says to her, yeah, just text it to me. And that's such a normal kind of interaction that we have in your common sense and life experience. You're headed out the door to run an errand, and someone in your home says, oh, while you're out, could you get me X, Y, and Z? And you're like, yeah, sure, just text it to me. Because you don't want to get there and be like, oh, what did they want me to get? It's such a normal interaction, right? Can you get this for me? Sure, text it to me. And he heads out the door, and she texts it to him at 5:15 p.m. And then he goes to CVS. Even though she's told him what to get and they have it, he still makes that call at 5:33. She calls him back at 5:34, and then he heads out to 3V and then comes home. And when he gets home, puts the things on the counter, and it's quiet. It's quiet in a way that a house with 3 kids under 5 should not be during waking hours. So he calls out to them, no answer. He goes to the basement door and opens it and yells down, and no answer. And he closes the door. He calls her phone, no answer. He goes upstairs and is able to unlock the door and see the blood and see the window open and go down to her. And when he goes down to her, she's no longer actively bleeding. He doesn't have to put pressure on any of her wounds. And he says to her, what did you do? And her response is, I tried to kill myself. And then it's, where are the kids? In the basement. It's not, I heard a voice, I was compelled to do this, I didn't want to do this, go help the kids, they're hurt, they're in the basement, go save them. No. It's, I tried to kill myself, and the kids are in the basement. And defense wants you to believe that conversation couldn't have happened because of how she sounded on the 911 call. But you heard from the doctors, people can deteriorate over time. When he first gets there, she's able to talk to him. And as that progresses, she's losing the ability to talk. And there's nothing in the medical records about her throat being crushed or her thyroid being crushed. You can look at that. Her thyroid was bruised, her vertebrae were broken, but her throat wasn't crushed. She had the ability to make sound and to communicate. And if you listen to the 911, he's talking to her, and then he's answering the 911 dispatchers about what she said. So even if we can't hear her clearly and we can't understand what she was saying, he could. You know from all of the evidence that you have, putting aside the experts, but all the evidence you have in terms of crime scene photos and videos and the witness testimony and all the medical records, you know how she killed them, where she killed them, what time she killed them, and the order that she killed them in. Even without what she told the doctors about the order, that's something you can infer from the evidence. Because you know, in order to bring the kids to the basement and strangle each one of them, and then come upstairs and get a knife and have a phone call, and then go upstairs to the second floor and either take handfuls of pills or crush them, however she did it, take the pills, and then cut herself. And it's not just 3 cuts, it's the hesitation marks, and then the cuts themselves. And then you know she bled in a couple spots for a little while, because you heard from Sherry Crook how the pooling in front of the mirror is someone, basically the blood dropping down and someone there for a period of time, and then over closer to the window, the same thing. So she's bleeding in front of the mirror for a period of time, over by the window for a period of time, and then she goes out of the window. And whether she dove out or climbed out and slid down, whatever you think that evidence shows from the shingles and everything you've seen, whatever happened, she goes out of the window and she's on the ground. And by the time Patrick gets there, she's no longer bleeding. So for all of that to happen in that short amount of time while Patrick's gone, she had to have started killing the kids immediately after he left. Now, defense wants you to believe that it was after the phone call, that after the phone call, she heard the voice and killed the children. But there's a few things about that don't make sense. First is what she told Dr. Satoff, that when she gets the call, she's at the fridge getting chicken nuggets out of the fridge to make dinner. You heard from Patrick, when he's leaving, Dawson is sitting on the couch eating chicken nuggets and green beans out of a bowl. There's the crime scene photo of 2 bowls on the couch. Yes, the pink one seems to have some vegetables in it, but there's the blue one there as well. And Patrick saw Dawson eating the chicken nuggets and green beans. So why would the defendant make that up? Why would she say she's doing that during the phone call? Because if she's already killed the kids because of a voice and being compelled and it being against her will and she's like a puppet, then she can't get a call and miss it and then call the person back and have a conversation and then hang up. A puppet can't do those things. Those are decisions and choices and actions that she's controlling. So she has to explain away the phone call because her behavior and her ability to have the phone call don't make sense if she's being compelled by her voice, if she's not in control. And you, further on that, you have the phone. You have the flights climbed. There were 2 flights climbed. You can see, you have Ian Whiffin's report, you can see there were 2 flights climbed. The first ends at 5:33. So it makes sense that she has killed the kids in the basement and she has come up the stairs, and at 5:33, she's in the kitchen and she's getting the knife. And then Patrick calls. Everything she's done, everything from the research to making sure what they had, to telling him to get it, to making sure it's on stock, all of that, and he still calls her, he still interrupts her. And then she gets the knife and she goes upstairs, and she's at the top of the stairs by 5:38. So the phone calls from 5:33 to just before 5:35. So if you want to believe that the voice happened after the call, and the killing of the kids happened after the call, between 5:33 and 5:38, she doesn't go down and come back up and come back up and come back up. There's nothing on that phone about that. And there wouldn't be enough time for her to bring those kids down to the basement and strangle each one in 3 minutes. You heard from the doctors, and Dr. Lapisato included, it could take up to 30 seconds for each child to go unconscious. And then strangulation would have to continue for another 1 to 2 minutes to cause death. And Dr. Lapisato wanted you to believe that the band could just stay there around their necks by themselves. But you have the bands. They're exercise bands. You pull them, they resist, you let go, they snap back. I had to hold them up to show her in circles like around someone's neck. And when I let go, they expanded. They don't stay around someone's neck on their own. You have to pull them. And you know they weren't knotted. Patrick never testified that they were knotted, so I'll take this one. He testified that he didn't have a clear memory, but he remembered that they were possibly looped. And I asked him, like, when you're tying your shoe, that first loop before you do a bow? And he said, yeah, kind of like that. So not knotted, not tied, but even his memory wasn't the best. You heard him on that call. And that's why we had to play the call for you, because you could hear him. You could hear when he found each kid. And you knew that he had the phone with him when he found each kid, because his voice, it never sounded like he was in another room. It always sounded so painfully right there. And so you know he's holding the phone and he's not untying knots, and he wouldn't have had the time to untie knots in that short amount of time. And then you have the firefighters looking in the window, seeing him with Dawson, and he's not untying a knot or unlooping something. They say they see him in an unwinding motion, unwrapping. That's why you had to listen to the 911, to show that she did stand over their limp bodies and strangle them for 1 to 2 minutes after they went unconscious. Because those weren't knotted, they weren't tied. They don't just stay there on their own. And even if you wanted to believe that at 5:38, she goes upstairs and puts the phone on the bed, and then she goes down and kills the kids, and she does everything. 5:38 to just after 6 p.m., because he's making the call to her at 6:09. There was not enough time between 5:38 and just after 6 p.m. to kill all 3 kids, to get the knife, to take the pills, to cut herself, to bleed, to go out of the window, to stop bleeding, and Patrick to get there. In 20-odd minutes, it's not enough time. So you know she killed those kids as soon as he left. And when she got the call from him, she had already strangled them. And she didn't tell him. She didn't ask for help. She didn't say, oh my God, what have I done? She's a nurse. She didn't go down and try to do CPR and help them. No, she lied. She stayed calm. She presented herself as normal. She had complete control over her behavior and her emotions. She had a normal conversation with him because she didn't want him coming home, because she needed to finish her plan. She still had to kill herself. So why did she do it? Defense would have you believe that a mother who was this good, who loved her kids this much, which we're not denying, would never harm her kids this way unless she was so mentally ill that she was hearing these command voices and had no choice. But you know that's not the world we live in. Dr. Resnick told you, most women who kill their children do it in child abuse. Most women who kill their children don't do it because of mental illness. Mothers kill their children, and it's horrible and it's awful, but it happens. So why did she specifically do it? She was depressed. She was exhausted. She was done. She didn't want to try anymore. She felt damaged. But those kids were her protective factor. Those kids were keeping her from ending her misery. And so she had to remove the protective factor. And I'm not saying she was happy about it. I'm saying that it was what she had to do to end her misery. But it was a choice. It was a choice. She could have kept trying. She could have, moved down to her mother's. She could have killed herself and left her kids alive. But it was a choice to take them with her. It was a horrible choice. And it's a choice that we don't want to think about that a mother could make, because that doesn't make us feel safe or comfortable in this world. But it's a choice she made. She knew it was wrong because she sent Patrick out to do it. She could conform her behavior because she waited until he was gone and didn't tell him what was going on those phone calls, didn't call 911 for help, didn't lock herself in a bathroom upon hearing this voice. She knew it was wrong. She didn't take advantage of this situation. She created this situation, this opportunity to do what she wanted. And when she woke in the hospital, and she knew she was alive and the kids weren't, she knew what she did was wrong. She said she felt horrified. And then, while still with a tube in her throat, she's asking, do I have a lawyer? And it's not what defense said. It was after surgery and she's delirious. Look at the records. She had surgery on the 27th. She's asking if she has a lawyer on the 26th. Do I have a lawyer? Because she knows what she did was wrong. And then we get the justification, the excuse of the voice. And there are a few reasons why the voice doesn't make sense. The first is she immediately obeyed it. Dr. Resnick, their expert, the one who knows everything about postpartum psychosis, he teaches other psychiatrists and psychologists. He writes books and chapters and articles about how this is a huge red flag if someone immediately obeys a voice. You heard him talk about Andrea Yates, about how she heard voices to kill her children for months. And what did she do? She committed herself 5 times. She tried to kill herself twice to avoid harming her children. It is said that was all accurate.
Let's move on from that.
Lindsay Clancy hears his voice one time and does it. Doesn't try to lock herself in the bathroom, call Patrick, call 911. Doesn't try to leave. Leaving little children alone for 20, 30 minutes, not the greatest option, but it's better than killing them. She doesn't try any tactics to avoid the voice. She just obeys. Another red flag that Resnick was asked about and teaches and writes about is that she only heard the voice one time. She never heard it before, and she hasn't heard it since. So now that works. It's a red flag that she's making up the voice. Another one is that what she said the voice told her isn't consistent. At the hospital, she says the voice said, you have to kill your children so you can kill yourself because they'll suffer without you. What she tells a lot of the doctors is, it says, this is your last chance, you have to kill the kids so you can kill yourself. And then she tells the chaplain, a third version, you have to kill the kids so you can kill yourself because they're in danger. There's these three different versions. Another red flag, it doesn't make sense that she's saying the voice says all these different things. And then the fourth thing that doesn't make sense about the voice is that it's vague in its command. It doesn't tell her how to kill the kids, where, with what, nothing. It says kill the kids so you can kill yourself. So she had to choose where, the basement. She had to choose how, strangulation. She had to choose with what, exercise ban. Choose again, exercise ban. Choose again, exercise ban. She had to choose how to kill herself. Now, if you're being compelled by this voice, and you have no free will whatsoever, you're just your body's acting on the voice, why wouldn't you just kill yourself the same way you killed the children? You strangled them, you hanged yourself. That's acting on compulsion, that's no choice. She tried 3 different ways. And none of them similar to what happened to the kids. And I'll take this other quarter now and explain to you why we got into the superficiality of the wounds and why we got into the height of the window and why we got into how she didn't take enough pills to actually kill herself. We're not saying she didn't want to kill herself. We're talking about that third prong of suicidality that Dr. Satoff talked about. Remember, he talked about aloneness and feeling burdensome, but that third category, capability. She wanted to kill herself, but her natural instinct to live was fighting against that. So she took pills, but you heard the toxicologists, they were all at therapeutic levels or below, except the Seroquel, which was a little elevated. She cut herself, but you saw the cuts on the meaty part of her arm horizontally. No arteries, no major blood vessels. Didn't need to be stitched the next day. The one on her neck didn't need to be stitched at all. She knew as a nurse those weren't going to kill her, but she was trying. And then going out of the window, 12, 13 feet. She landed the wrong way and ended up paralyzed on the frozen ground. But, the idea that falling out of a 12-foot window is going to definitely kill you, not necessarily. And so she wanted to, she was trying in all these different ways. But she just couldn't get over that third prong, the capability of actually killing herself. And that goes against it being a voice. Because if she's compelled to do it, if this voice is making her do it, she would just do it. There would be no fight. There would be no struggle. There would be no resistance to dying. But there was. I guess the third one is Dr. Zeisel. We've never said that he told the defendant what to say. Not one witness, not one piece of evidence. The only person that said that Dr. Zeisel, that we were trying to say Dr. Zeisel told her to make up the voice, is defense counsel. He's the only one that asked about it. He's the only one that brought it up. We have never said that in this courtroom, and no witness has said that we've asked. She knew what she did was wrong. She could conform her behavior to the law and chose not to. And she didn't expect to have any consequences because she expected to die with her children. And we get to what we have to prove is that first degree is deliberate premeditation and extreme atrocity and cruelty. You know it was deliberate premeditation because of the way she killed them and the way they died. And the order also shows a rationality. The order she killed them in. Because Cora and Dawson are older. If she had tried to strangle one in front of the other, they would have known this is bad. And they would have tried to intervene or run and hide. And she had a very limited time. She didn't have time to try to find a child who ran off and hid. So taking Dawson first and moving him to a separate room, having Cora stay with Callan and having Dawson go in another room, that's rational. That makes sense. That's ordered thinking. And we didn't show you that post that she made about Dawson being a handful and not being compliant to show she was a bad mom. We showed it to you because it proves she knew that he was a handful. She knew that he was less likely to be compliant, to just go along. She knew that he might struggle. And so it made sense rationally to remove him and separate him first and kill him first. And she brought him into that room, into the office, and closed the door, and she wrapped that band around his little neck. And she squeezed until he was unconscious. As the blood's pooling in his face and causing those blood vessels to burst, causing him pain and panic and confusion. And defense calls Dr. La Posada to say, no, it wasn't 20 or 30 seconds, it was only 5 or 10 seconds until he went unconscious. I'm sorry, how many seconds is it okay for them to have been in pain and panic and confusion? How about it wasn't okay for 1 second for any of those children to feel that? And they all felt it, all for up to 30 seconds. And then she continued strangling their limp bodies for 1 to 2 minutes to make sure they were dead. Deliberate premeditation. And then extreme atrocity and cruelty. The indifference that she showed to their pain, to their struggle, to their suffering, leaving them there on the floor with the bands around their necks, completely indifferent, because she had a plan and she was following it through. Just think of that. The being strangled and the pain and the confusion that they're going through, and it's being done by their mom. Their mom is the one that's hurting them. Their mom is the one that's killing them. That's extreme atrocity and cruelty. She didn't see them in that moment as individual human beings with rights, with dreams, with futures, individually belonging to them. You heard about the 3 kids. Cora wanted to be a doctor and a mom. Dawson wanted to be a firefighter. Callan never got the chance to dream. Who knows what future he would have dreamed for himself. She killed them, and she left them there on the floor with the bands around their necks. She didn't bring them up to their beds and put them with their favorite stuffed animal and cover them up gently and lovingly, leaving them peacefully there. No. She left them discarded on the basement floor like broken toys because she was done playing the game. You know to a moral certainty, she is guilty.
All right, thank you, counsel. Now, members of the jury, been sitting here for a while. Does anybody need a short break? You think that would? All right. So we're going to return now to the instructions that I have. In rereading my instructions, I just kind of want to make sure that something's clear. So I'm going to ask you to go back to page 6. I think we were talking about murder in the second degree. Everybody get there. All right. And what I just kind of wanted to make clear, that you may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs, in determining any of the elements in the murder in the second degree charge as well. I mentioned that for some of the others, but and specifically for the charge in murder of the second degree, there's an element regarding intent. Okay, so I just kind of wanted to make that clear. Probably is suggested in that, but as I read through it, I just kind of wanted to remind you that you can, as I said, you can consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs in determining the elements in murder in the second degree. All right, so I hope that cleared things up rather than confusing you any. But now I'm going to go to the general principles in regards to this case. All right. Now, as I said to you before, I'm incorporating the instructions that I gave earlier before the closing arguments with these instructions. So I want to talk about the presumption of innocence and the burden of proof. Once again, the indictments against Ms. Clancy are only an accusation. They're not evidence. The defendant has denied that she's guilty of the crimes charged in these indictments. The law presumes the defendant to be innocent of the charges against her. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt. This burden of proof never shifts. The defendant is not required to call any witnesses or produce any evidence since she is presumed to be innocent. The presumption of innocence stays with the defendant unless and until the evidence convinces you, unanimously as a jury, that the defendant is guilty beyond a reasonable doubt. It requires you to find the defendant not guilty unless her guilt has been proved beyond a reasonable doubt. Your verdict, whether it is guilty or not guilty, must be unanimous. All right? Now, reasonable doubt. The burden is on the Commonwealth to prove beyond a reasonable doubt that the defendant is guilty of the charges made against her, as I just told you. But what is proof beyond a reasonable doubt? Well, the term is often used and probably pretty well understood, though it's not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you've compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, I want to talk initially about my function of the judge. My function as a judge in this case has been to see that the trial was conducted fairly, efficiently, and in an orderly manner. It's also my responsibility to rule on what you may consider as evidence and to instruct you on the law that applies in this case. It's your duty as jurors in this case to accept the law as I stated to you. You should consider all of my instructions as a whole. You may not ignore any instruction or give special attention to any one instruction. You must follow the law as I give it to you, whether you agree with it or not. That's not just because I'm the judge. It's because every person who comes to court for trial is equal and is subject to the same law. And if jurors in each case were to apply what they thought the law should be, and the jurors in different cases had different views, then the parties in those cases would not be treated equally. The law that I'm instructing you on is the law that has been established by our legislature and our appellate courts, and it applies to everyone. And you must apply the law as I instruct you. Function of the jury. Your function is to determine the facts of this case. You are the sole and exclusive judges of the facts. You alone determine what evidence to accept, how important any evidence is that you do accept, and what conclusions to draw from all the evidence. You must apply the law as I give it to you, to the facts as you determine them to be, in order to decide whether the Commonwealth has proven its case. You should determine the facts solely on a fair consideration of the evidence. You are to be completely fair and impartial, and you are not to be swayed by prejudice, by personal likes or dislikes towards either side, or by any personal view you may have the nature of the claims or the defenses in the case. Your decisions must rest solely on the facts that you find and the law that I give to you in these instructions. Nor are you to be influenced by any personal likes or dislikes you've come to feel towards any party or any attorney. In this courtroom, every person is equal and is entitled to a fair and impartial verdict in accordance with the evidence and the law. You are not to decide this case based on anything you may have read or heard outside of this courtroom. That, with the exception of that, is the observations you made at that view, and I'll talk about that a little bit later. You are not to engage in any guesswork about any unanswered questions that remain in your mind, or to speculate about what the quote-unquote real facts might or might not have been, beyond what has been proved by the evidence. You should not consider anything that I've said or done during the trial as any indication of any opinions as to how you should decide this case. If you believe that I've expressed or hinted at any opinion about the facts of this case, please disregard it. I have no opinion about the facts or what your verdict ought to be. That is solely and exclusively your duty and your responsibility. Now, I'll talk about function of counsel. It was the duty of the lawyers in this case to object when the other side offered evidence which that lawyer believed was not admissible under our law. They also had an obligation to ask to speak to me at the sidebar about questions of law which the law requires me to rule on outside of your hearing. The purpose of such objections in rulings is not to keep relevant information from you. You should not draw any inference, favorable or unfavorable, to any attorney or their client for objecting to proposed evidence or asking me to make such rulings. That is the function and responsibility of the attorneys in this case. Now, what is evidence? As I told you, you are to decide what the facts are solely from the evidence admitted in this case and not from suspicion or conjecture. The evidence consists of the testimony of witnesses as you recall it, and any documents, photographs, or videos or other things that were received into evidence as exhibits. You may also consider any observations that you made while at the view that we took earlier in the trial. In this case, there may be certain documents or photographs that are entered multiple times. This does not mean that that evidence is any more or less important than any other evidence. You, the jurors, will decide how to evaluate the evidence, that is, what weight to put to it. Now, in reviewing documents and evidence, you might find that there's some information that's been whited out or redacted. This is because the court has made some legal rulings about what evidence is relevant to this case. You should not draw any negative inference against either party based on these redactions, nor are you to speculate about what information has been redacted. In addition, a couple of stipulations were entered into evidence during the course of this trial. A stipulation is an agreement that has been made between the parties. The contents of such stipulation may be accepted by you as facts and relied on you along with other facts that you find
I don't know. Can y'all hear me? Put a 1 in the chat if you're able to hear me. I don't know. It's telling me we detected audio in your stream belonging to someone else. I have no clue what that means. I'm just using courtroom feed, so I don't know. I was not sure. I've never had this issue before, so I don't know what this is about. I don't know. I don't know if it's something with YouTube AI. I don't know. So I can't really tell you why it would stop. Yeah, because they can't claim any testimony. Like, this is testimony. Like, everybody has access to the same stuff. So, I don't know. I don't know. I see the stream too. Your stream has been snipped. I don't know. Let me see. Let me check something else. Can you see me? Or you can just hear me?
Will count how good an opportunity the witness.
So you can't see me? I don't know. Let me see. I don't even know. I don't know. I've never had that happen before. It sounds stupid. So when I put the courtroom feed up, you don't see anything? Let me see. So can y'all see the courtroom feed now? Just a frozen screen?
Had to observe the
What about
facts
now?
about which the witness testifies, the degree of intelligence the witness shows, and whether the witness's memory seems accurate. You may also consider any motive that the witness may have for testifying and whether the witness displays any bias in testifying and whether or not the witness has any interest in the outcome of the case. Now, I want to talk a little bit about prior inconsistent statements. When you evaluate the testimony the witness gave here in court, you may consider whether that witness made any earlier statements that differ from or contradict in any way their in-court testimony. That earlier statement is generally admitted into evidence solely for your consideration in evaluating the witness's credibility or believability. If you determine that an earlier statement is different from the way the witness testified in court, you may decide that the witness's credibility or believability is affected adversely, or you may decide that it's not adversely affected, but that is the only purpose for which you may use that earlier statement. You may not consider the earlier statement as evidence or proof of truth of any fact contained in the statement. Now, flip side, I want to talk about prior consistent statements now, all right? The testimony of a witness may be rehabilitated or supported by showing that he or she previously made statements that are consistent with their present testimony. The prior statement is admitted into evidence solely for your consideration in evaluating the credibility of the witness. Should you find the prior statement to be consistent, you may consider the prior statement only in connection with your evaluation of the credence to be given to the witness's present testimony in court. You are not to consider the prior statement as establishing the truth of any facts contained in that statement. Now, I want to talk about the defendant's statements that were made to evaluating psychiatrists or psychologists. You may not consider the defendant's statements made to a psychiatrist or psychologist in their evaluation of the defendant as establishing the truth of any facts contained therein. Those statements cannot be used by you as evidence of premeditation, extreme atrocity, or cruelty, or specific intent to kill. Such statements are admissible only as they relate to the basis of the doctor's opinion of the defendant's mental condition. Now, I want to talk about evidence of post-incident conduct. Now, if you have heard some evidence suggesting the defendant's actions after the killings. I'm not suggesting that these are the facts, because the facts are your exclusive domain. But there is some evidence to that effect, and I mention it here to describe the legal point that's implicated. If the Commonwealth has proven that a defendant did any of these things, you may consider whether such actions indicate feelings or consciousness of guilt by the defendant, and whether in turn such feelings of guilt might tend to show the defendant's actual guilt of the offenses with which he's been charged. You are not, however, required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all the circumstances in this case. If you decide that such...
And it's doing it again. I don't know. Yeah, I see it's doing it again. Yeah, it's telling me it's because of policy violations. I don't know what violation I done did. Did it do that before? Can y'all still hear me? Put a 1 in the chat if you can hear me. Oh, gosh. Yeah. Hold on, guys. I'm trying to check on something to see if we can get past it. Yeah, I guess I can only I don't know.
such inferences are reasonable, it will be up to you to determine how much importance to give them. But you should always remember that there may be numerous reasons why a person not responsible for the crimes charged might do the things attributed to her. Such conduct does not necessarily reflect feelings or consciousness of guilt. So please bear in mind that a person having feelings of guilt is not necessarily guilty, in fact, for such feelings are sometimes found in innocent people. So finally, remember that standing alone, Consciousness of guilt evidence, if you find there was any, is never enough by itself to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence that was presented at the trial. I want to talk next about expert witnesses. Now, there were a number of expert witnesses in this case. This term refers to witnesses who have specialized training or experience in a particular field. Generally, in cases that are tried in our courts, both civil and criminal, witnesses may testify only to facts that are within their own personal knowledge, that is, things they have personally seen or heard or felt. Because a particular witness has specialized training in their field does not put that witness on a higher level than any other witness, and you are to treat an expert witness just as you would treat any other witness. You may believe all of the expert's testimony, none of it, or anything between those two extremes. There is no requirement for you to believe an expert merely because they are an expert. As with any other witness, it's completely up to you to decide whether you accept the testimony of an expert witness, including the opinions that the witness.
Yeah, I'm over it. All right, guys. Yeah, it's not gonna let me play the Lindsay Clancy stuff. I have no clue, and it's just gonna keep stopping it in the middle. I'm kind of like watching it on my phone. So, and I could see that no, because I'm not even trying to Gabber, I'm not even using, like, I was using Law and Crime, and then I was using another station. But this is just it's natural feed, and everybody just throw their stamp of approval on it and just change stuff around or whatever the case may be. But yeah, I'm not that deep into the Lindsay Clancy thing for that part of it to keep stopping the stream like this and making it like this. I'm just glad that we were able to get through closing statements. I am going to go ahead and try to I'm gonna get my stuff together for the Mo 3 trial, and I'm just gonna back out of this. I'll watch on the thing by myself, individually, to see when he ends and when they start their deliberations. I'll still put up a verdict clock and everything like that. But yeah, I'm not about to go through this with them because I'm not into this. At this point in time, I'm just over this trial. So if you want to kick me out, I'm gonna let it kick me out. All right, guys. So sorry about that. I'm gonna go ahead and end the stream. I'll put out alert because I'm going into Mo 3 afterwards because Tupac does not start until later today. And hopefully I'll see you guys over there. All right, peace.